I first want to begin and commend the college and the faculty for handing out this document. This is a very radical document. It's about freedom, it's about justice, and it's about equality for all. And on September 17th, we celebrate the Constitution, and too many people, in my opinion, don't know what's in this document. So I'm going to refer to it a lot today, but I really encourage all of you to take a look at it, especially these days, because this is the roadmap. In fact, if you don't like what's going on, this is the roadmap to challenge and oppose. It is indeed an honor and a privilege to be here today, and I want to thank Sean and President Camille for the opportunity to speak to you, especially on such an important topic. The issue of freedom of the press has always been a fundamental cornerstone of this nation and is front and center, and once again controversial in the year 2017. My topic, freedom of the press, needed more than ever, is extremely timely. Let me first read the First Amendment to the Constitution of the United States. It's actually 6 amendments. Congress shall make no law. And through the case law, it's not just Congress on the federal level, but the state government and local governments. They're applicable under the First Amendment as well. So Congress and those government entities shall make no law, 1, respecting an establishment of religion, 2, prohibiting the free exercise thereof, known as the Free Exercise Clause, or abridging the freedom of speech, the fact that you have the right to say what you want, except there are some exceptions. In question and answers, I'll address the exceptions. Number 4, or abridging freedom of the press, the right to write whatever you want, or today to go on your cell phones, the internet, and not to be punished for expressing your views. 5, the right of the people peaceably to assemble. One of the cases I'll be reading today is about exactly that in the Southern Civil Rights Movement. And I say Southern because I don't think we've had a national civil rights movement yet. We had a Southern Civil Rights Movement. And finally, to petition the government for redress of grievances. My talk today is going to be on the issue of freedom of the press. It was in the early 1700s that a German immigrant to New York, John Peter Zenger, became, to use a modern term, the poster person for freedom of the press. On November 5, in the year 1733, none of us were around then, Zenger began publishing the New York Weekly Journal. The paper contained articles that were negative about the British governor of New York. His name was William Cosby, and his administration. The governor, Cosby, did not respond graciously. As most politicians, he didn't like negative comments about him and his administration. Mr. Zenger was arrested for what was called seditious libel. So there was a trial that began in August 1735. A lawyer named Andrew Hamilton, not Alexander Hamilton, but Andrew Hamilton, represented Zenger. Hamilton argued very simply that it was wrong to arrest a man for telling the truth. I'm going to quote some of his summation, but just by a show of hands, how many people here pre-law or thinking of being a lawyer? All right, we've got a handful. And even for the ones who aren't, I strongly recommend that you go to a library or even go on the internet and look up John Peter Zenger and go to the transcript of the trial. It's always helpful to go to the original source, not just what someone interprets, but the original source. And some of the language is very rich. For example, Hamilton, in his summation to the jury, says, "If you should be of opinion that there is no falsehood in Mr. Zenger's papers, you ought to say so. It is your right to do so, and there is much depending upon your resolution as well as upon your integrity." He's beginning to get to the jury because what he wants them to do is the right thing, which is not to hold Zenger guilty of libel. And what he's wanting to do is to confirm and encourage them to do the right thing. Men who injure and oppress the people under their administration provoke them to cry out and complain, and then make that very complaint the foundation for new oppression and prosecutions. His concluding remarks. The question before the court and you gentlemen, footnote, back then, all men on the jury. It took a long time for this country to finally get to the point with a new amendment about the rights of women, and we're still not where we should be on that issue. Of the jury is not of small nor private concern. It is not the cause of a poor printer, which was Zenger, nor of New York alone, where this was taking place, which you are trying. No. It may in its consequence affect every, again, free man that lives under a British government on the main of America. It is the best cause. It is the cause of liberty. And I make no doubt, here's where he begins to deal with their emotions. I make no doubt but your upright conduct this day will not only entitle you to the love and esteem of your fellow citizens, but every man, I'd say every person, who prefers freedom to a life of slavery will bless and honor you as men who have baffled the attempt of tyranny and by an impartial and uncorrupt verdict have laid a noble foundation for securing to ourselves, our posterity, and our neighbors, that to which nature and the laws of our country have given us a right, the liberty, both of exposing and opposing arbitrary power by speaking and writing truth. Truth to power, as many modern-day protesters chant over and over again. The jury, after meeting reportedly for only 10 minutes after Hamilton's remarks, reached the verdict of not guilty. The Zenger not guilty verdict became an early precedent for the significance and importance of both free speech and a free press. Truth was now an acceptable defense to the charge of libel. Previously to the Zenger trial, even if you spoke the truth, but you were critical of people in power, of the government, you could be punished. John Peter Zenger, a New Yorker, became the iconic symbol of what a free press means in America. You could speak the truth to governmental power and not be committing a crime nor be punished. Now that was 282 years ago. Since then, there have been many free press cases that have built upon the Zenger precedent. I will, in light of the constraints on time today, I could go all day today, I will read from two of what I believe are the seminal cases decided by the United States Supreme Court that discuss the modern-day standards and importance of a free press. The first case is a 1964 case entitled New York Times versus Sullivan. This was about the Southern Civil Rights Movement. It was about an ad that was taken in the New York Times. It was entitled, "Heed Their Rising Voices." In essence, and I'll go through it in a little detail, but in essence, it was Southern clergy people and Southern activists, including Dr. Martin Luther King Jr., who were taking out an ad a full-page ad in the New York Times, talking about the plight of what the demonstrators were going through and calling upon the rest of America to support them, and most important, to send in contributions so the movement can then continue. When it came to the U.S. Supreme Court, there's 9 Supreme Court justices. In this case, all of them were in agreement on the outcome of this case. Justice William Brennan wrote the majority decision. He was a Republican appointee from New Jersey, to make the point that it's not just partisan when it comes to fundamental rights in America. Brennan, and I quote, "We are required in this case to determine for the first time the extent to which the constitutional protections for speech and press limit a state's power to award damages in a libel action brought by a public official against critics of his official conduct. The people versus the power. The people versus the government official." So who was the specific defendant here? Sullivan. He was a commissioner from the city of Montgomery, Alabama, where a lot of the demonstrations back then were taking place. He was also the supervisor of the police department. And he brought a libel action against 4 individual Alabama clergymen and the New York Times. And a jury in the lower court in Montgomery held against the individuals and held for Sullivan and awarded damages of $500,000. Now back then, that was a lot of money. To me, that's a lot of money even today. But back then it was even more so. If you multiplied it maybe by 10, you're talking about an award of $5 million. And the Times and the clergy people appealed it to the Supreme Court of Alabama, and they upheld the lower court decision. So they went to the U.S. Supreme Court. The Supreme Court took the case, and here's what part of the ad that became controversial, and I'll read part of it to you. It was entitled, "Heed Their Rising Voices." The advertisement began by stating that, quote, "As the whole world knows now, because of TV, thousands of Southern," and the word in the decision was a word that was used at that time, the word Negro. We don't use that word today. "Southern Negro students are engaged in widespread nonviolent demonstrations in positive affirmation of the right to live in human dignity as guaranteed by the U.S. Constitution and the Bill of Rights, first 10 amendments." It went on to charge that in their efforts to uphold these guarantees, they were being met by an unprecedented wave of terror by those who would deny and negate that document, which the whole world looks upon as settling the pattern for modern freedom. Succeeding paragraphs purported to illustrate the wave of terror by describing certain alleged events. The text concluded with an appeal for funds for 3 purposes: support of the student movement, 2, the struggle for the right to vote, and the legal defense of Dr. Martin Luther King, leader of the movement, against the perjury indictment that was pending in Montgomery. There were 10 paragraphs in the ad. The 3rd and the 6th paragraph became the crux of the lawsuit. 3rd paragraph said, "In Montgomery, Alabama, after students sang 'My Country 'Tis of Thee' on the state capitol steps, the leaders were expelled from school, and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus, when the entire student body protested the state authorities by refusing to re-register. Their dining hall was padlocked in an attempt to starve them into submission." The 6th paragraph, "Again and again, the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home, almost killing his wife, Coretta, and children. They have assaulted his person. Key, they have arrested him 7 times for speeding, loitering, and similar offenses. And now they have charged him with perjury, a felony which could imprison him for 10 years. So the lawsuit was about that some of the stuff that I just read you was not true. And that if you make false statements and you're writing it, it's libel. If you make a false statement speaking, it's called slander. It's all under the category of defamation. Defamation, libel, written, slander, speaking. So this was an ad. So they claimed it was libel. Going on with the decision. Court said it is uncontroverted that some of the statements contained in the 2 paragraphs were not accurate. Here's what the court said was the inaccuracies. And remember, the framework here is if it's false, it's libel until this case. Although Negro students staged a demonstration in state capitol steps, they sang the national anthem and not My Country 'Tis of Thee. That was the first allegation of a false statement. Second, although 9 students were expelled by the State Board of Education, this was not for leading the demonstrations at the Capitol, but for demanding service at a lunch counter in Montgomery County. If you read your history part of the beginning of the Southern Civil Rights Movement with students, mainly black, but some white, who went into lunch counters where they wouldn't serve the black students. And they'd sit there. People poured stuff over our heads, kicked us, had dogs, signed on us, but people kept doing it in order to integrate the public accommodations. So they got that one falsely alleged. Third, not the entire student, but most of the entire student had protested the expulsion refusing not to register, but by boycotting classes on a single day. The campus dining hall was not padlocked on any occasion. They did not at any time ring the campus. And finally, the big falsehood where the ad said that Dr. King had been arrested 7 times. The truth was he was arrested merely 4 times. So you're getting the gist of what the Supreme Court is dealing with, that in the context of what libel is about, false statements, here this official in Montgomery, Alabama is suing Dr. King, people in the Southern Civil Rights Movement because of false statements. So that's the facts in that case. So the question then becomes, well, what does the U.S. Supreme Court do? Well, here's some of what the Supreme Court said, and this became precedent to change the way freedom of press was dealt with in America in modern times. We reverse the judgment. We hold that the rule of law applied by the Alabama courts is constitutionally deficient for failure to provide the safeguards for freedom of speech and freedom of the press that are required by the First and 14th Amendment in a libel action brought by a public official against critics of his official conduct. The general proposition that freedom of expression upon public questions is secured by the First Amendment has long been settled by our decisions. The constitutional safeguard, we have said, was fashioned to assure unfettered interchange of ideas for bringing about political and social changes desired by the people. We consider this case against the backdrop of a profound national commitment to the principles that debate on public issues should be, and here's key language, uninhibited, robust, and open, wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. The present advertisement was an expression of grievance and protest on one of the public major issues of our time, would seem clearly qualified for the constitutional protection. The question is whether it forfeits that protection by the falsity of some of its factual statements and by its alleged defamation. The court then recognized that when people do things, we're not pure, we're not perfect, we don't always get it right. So you have to put it in context. The courts over the years say if you're making statements that are false about a private individual, about a private matter, that's a different standard than if we as citizens take on the president or the governor or the mayor or even a college president. Not that I'm saying you should do that, but that you have a right. Because we make a commitment that we want people to say what they think and what they feel. Because if it's an issue of public concern, we should hear it. We don't want ideas to go underground. We want it out front, because under the First Amendment, if you have bad ideas, how do you fight bad ideas? You don't censor the bad idea. You expose the bad idea to good ideas. That's the whole concept of a marketplace of ideas. Too many people want to censor the bigots, the people who engage in negative comments. My position, that's the worst strategy. Put them out there. Put the sunlight on. Hear their idiotic thoughts, and then debate them. It should be easy on the merits to defeat the bad ideas. And if your idea at that moment is not accepted, that's the challenge. The challenge to persuade people. Not to put a gun to their head. You put a gun to their head, they'll say what you want. As soon as you take that gun away, they're not saying what you want them anymore. You got to appeal to people's mind and their heart. And that's the beauty of the First Amendment. So, in this case, the court basically said, a rule compelling the critic of official conduct to guarantee the truth of his or her factual assertions, and to do so on pain of libel judgments, especially $500,000 at that point, virtually unlimited amount, leads to a comparable self-censorship. What they're saying here is that if we don't have a strong First Amendment, and you know if you're going to say something, you're going to be punished, either financially or fired from your job, expelled from your school, most rational, reasonable people are going to self-censor their ideas. But we don't want that. We want it to be out there. Newspaper this morning, I read about a commentator on ESPN. She said some things on her Twitter account. I agree with her, but even if I didn't agree with her, she should have the right to say that. And then immediately someone says she should be fired. Interesting thing about the First Amendment, if I get up here and I say every single thing that all of you agree with, that's easy. You support my right to say that, right? That's not the test of whether you believe in the First Amendment. The test is, if I get up here and say X, Y, and Z, and you all disagree with X, Y, and Z, are you going to allow me to say it? Or are you going to say, don't let him come? Professor Camille, we heard he says X, Y, and Z. We find that offensive. Don't let him come to the campus. Don't let him speak. That's starting to happen on a lot of college campuses across the country, including the school that began the whole free speech movement, University of California, Berkeley. They recently would not allow conservative speakers to appear. That's not what the First Amendment's about. And in the context of freedom of the press, in this case, what the court was holding was that even when they got it wrong, and they said Dr. King was arrested 7 times when he was only arrested 4, and when they sang the national anthem rather than My Country 'Tis of Thee, you can't punish people because of that. The second case I want to talk about is a case called United States versus the New York Times and the Washington Post. How many here either heard, let's see, this would have been in the 70s, so none of you were, except for the faculty who were alive, maybe you learned in history. How many people have ever heard of the Pentagon Papers in the Vietnam period? Okay, well that's what this case was about. What this case was about was the court took the case. This one was not unanimous, it was 6-3. And there were strong views on that. And the background here was a guy named Daniel Ellsberg. How many people ever heard of Daniel Ellsberg? All right, well, he was a government employee. He got a hold of this study known as the Pentagon Papers, made a Xerox copy. People heard about Xeroxing, okay? And in the context, he gave it to the New York Times and the Washington Post. Government officials, can't do that. It affects our national security. They wanted and went to court to get what's called a prior restraint on the press, to not allow the press to report that. The press didn't do anything other than take the document and published it. So the court granted certiorari, meaning they take the case, and the court held, and then I'm going to read some of the parts from this decision because, again, I think it's really, in my opinion, very rich in content. The court held that the government had not met its burden of showing justification for the imposition of a restraint on publication on the contents of the study. The court was saying that the press has the right to publish this, and that the government, including the President of the United States at that time, cannot stop the press from publishing something that they feel would be detrimental to the national interests. The government had the burden of proof to come in to show that the publication of this document would somehow interfere with our national security and the war in Vietnam. But the document was showing that the government, according to the case law, was misleading the public as to why we were in Vietnam. And this individual was what was now we call a whistleblower. Not just that, a whistleblower is someone who gets certain documents and then makes it public. Whistleblowers are weird people, strange people. They take a certain kind of personality to do that because very often they could wind up in jail. And in this case, the court came to the defense of both the New York Times and the Washington Post on the grounds of freedom of the press. And once again, very important, because how are we, the people, how do we hold the government accountable? How do we know what the government is doing in our name? Is it really in our name, or is it in their special interests? Some very rich language here. Justice Hugo Black from Alabama. He and William Douglas were the strongest proponents of free press and free speech. Both of them are heroes of mine. Black saying, "Our government was launched in 1789 with the adoption of the Constitution. The Bill of Rights, including the First Amendment, followed in 1791. I sound like a history professor here. Now, for the first time in 182 years since the founding of the Republic, the federal courts are asked to hold that the First Amendment does not mean what it says, but rather means that the government can halt the publication of current news of vital importance to the people of this country. In seeking injunctions, an injunction is to stop something from happening. These newspapers, and in its presentation to the court, the executive branch seems to have forgotten," he's being critical here, "the essential purpose and history of the First Amendment. Now he's going to give it to us. When the Constitution was adopted, many people strongly opposed it because the document contained no Bill of Rights to safeguard certain basic freedoms. They essentially feared that new powers granted to a central government might be interpreted to permit the government to curtail freedom of religion, press, assembly, and speech. In response to the overwhelming public clamor, James Madison, another important person in our history, offered a series of amendments, the Bill of Rights, to satisfy citizens that these great liberties would remain safe and beyond the power of government to abridge. Madison proposed what later became the First Amendment, one of which proclaimed, "The people shall not be deprived or abridged of their right to speak, to write, or to publish their sentiments, and the freedom of the press is one of the great bulwarks of liberty, shall not be violated." The Bill of Rights changed the original Constitution into a new charter in which no branch of government could abridge people's freedom of press, speech, religion, and assembly. They go on, and he says, to find that the president has inherent power to halt the publication of news by resort to the courts would wipe out the First Amendment and destroy the fundamental liberty and security of the very people the government hopes to make secure. He ends with, secrecy in government is fundamentally anti-democratic, perpetuating bureaucratic errors. Open debate and discussion of public issues are vital to our national health. On public questions, there should be, and here's these magic words that I told you before from the previous case, and that's how the courts create precedent. Something in 64 then becomes the basis for the premise of a decision 10 years later. He says on public questions, there should be, quote, uninhibited, robust, and wide open debate. I strongly urge for not just the people who might want to become lawyers, but for the people, in fact, everyone here. These two cases, New York Times versus Sullivan and U.S. versus New York Times and Washington Post, read them. It might not be the most exciting novel you ever read, but in reading this stuff, you get a sense of the history of what makes America unique. And it's not just the rhetoric, but the challenge for all of us is take those words and make them a reality. It's the words that our government and our nation says they believe in. So let's make it a reality. When I went to Mississippi in 1966 to be in the Southern Civil Rights Movement as a kid from Brooklyn, New York, his parents never graduated high school, let alone college. I came from a working class family. But I remembered in my high school in Utrecht and Bensonhurst, teachers told me about what America was about. And we took that pledge to the flag. And we taught about equality for all. And when I went to Mississippi in '66, I realized I had been duped. It wasn't equality for all. Black people in the South, they weren't being treated equally. I remember the signs for coloreds only. We went to the movie theater. I had been on the first floor. My black friends had to go on the balcony. They couldn't come down to the first floor, and I couldn't go up to the balcony. It was wrong. And I remember in June of '66 one night saying to myself, so what do I do now? And I vowed I'm going to make them eat those words. It was Brooklyn language at that point. Make them eat the words. Today I would say I'd make them live up to their commitment to freedom, justice, and equality. For all, not just some. So in reading these decisions, you get the framework and the foundation for what America is supposed to be about. And the challenge for all of you, especially the young folks here, is make them live by those words. Make them live by freedom of the speech. Make them live by freedom of the press. And when people empowered take those rights away from us, be smart. Be efficient. Win. Which means this and this strategy, and use the Constitution as your roadmap to fight back. So now let's fast forward to 2017. And I'm glad I told you before about if I say X, Y, and Z, you don't agree with me, you let me speak. You don't throw me off the campus immediately. Donald Trump is elected the 45th President of the United States. Very soon after being sworn in, the President stated, and I quote, "The press has become so dishonest. Many of our nation's reporters will not tell the truth." And his former assistant, thank God for that, and chief strategist stated that he considers the media to be, quote, "the opposition party." The opposition party. And the media should, using Brooklyn terms, keep its mouth shut, period. These statements were consistent, in my opinion, with the tone and comments during candidate Trump's 2016 campaign. It set the tone of attempting to turn the public, us, against the media, and to undermine the principles of freedom of the press that I just spent some time laying out for you. A few weeks ago, the President in a Phoenix, Arizona, 2020 campaign rally, 2017 already doing his campaign for 2020, continued his attack on the press. He said, and I quote, "It's time to expose the crooked media deceptions." He likes the word crooked. Quote, "They're very dishonest people." President Trump repeatedly calls the media, quote, "fake news." He repeatedly criticizes the failing New York Times, they're not failing, and continuously attacks the Washington Post and CNN. In February 2017, the White House had a press briefing and excluded some news organizations. They selectively chose and permitted news organizations that were favorable to the Trump administration to attend the briefing. And then they banned the New York Times, CNN, the LA Times, the New York Daily News, Politica, BuzzFeed, BBC, the Huffington Post, and The Guardian. News organizations that have been critical of President Trump and his administration. In 2009, the Obama administration excluded Fox News from press access for a brief period. So the point I'm making, it's not exclusively one side or the other. It's people in government, again, people in power, who don't like when people say things that are critical of them. They want you to say good things about them. Whether it's the Trump administration or the Obama administration, selectively including and excluding the press based on their viewpoints, in my opinion, is not only wrong, it's prohibited viewpoint discrimination under the First Amendment of the U.S. Constitution. The bottom line is that freedom of the press is a bedrock principle of our Constitution and an integral part of what makes America sui generis. Sui generis means one of a kind. We need to recognize the extreme importance of the principle of freedom of the press. Because if we don't understand and appreciate the role of the press, and what is that role? To discover and report the news to us, the people, especially about our government officials, we would incrementally lose that precious freedom. History tells us that usually we don't lose our freedoms and our rights overnight with a big bang. What history tells us is we lose them little by little, day by day, until one day we wake up and that freedom, that right that we took for granted, has disappeared and we can't get it back. Once it's gone, you can't get it back. Together, yes, together, I hope we will not let that happen. Recently, Nicholas Kristof, a columnist in the New York Times, summed up this point very nicely when he wrote, and I quote, "This is an extraordinary moment in our nation's history, for we are enduring an epic struggle of the principles on which our country was founded. These include the idea that a flawed free press is an essential check on flawed leaders. Flawed free press, recognizing they're not perfect. Who among us is? That flawed free press is essential as an institutional check on flawed leaders, and we got plenty of them. Let me conclude. America is founded on the principle and value of freedom of speech and freedom of the press. We as a people, as a nation, are very proud of this principle and value. It makes us stronger and freer as a nation. It assists us in keeping informed and holding government officials accountable. We cannot and should not let it erode. We as a nation, even in the face of strong opposition and cynicism, have demonstrated over and over again our willingness to fight back for what we hold dear and cherish as part of our freedom, our rights, and our identity. We have prevailed before, and I am confident we will prevail again in the defense of freedom of the press. Please remember, freedom of the press, needed now, needed now, needed now more than ever. Thank you very much.